Okay. Hello, everyone. Hello. Thank you for coming. I am Robin Knox. I am on the board of directors for OEN. Maggie could not be here. She's quarantined. She does not feel well at all, so boo, but I'm glad I can be here. I would like to welcome, we have some people to welcome and thank our sponsors. Tonight, what?
Yes, let's thank the sponsors.
Yeah, we're going to thank the sponsors. Let's thank the sponsors. Our first sponsor is Davis Wright Tremaine, and I would like you to help me welcome Michael Phillips to say a little thing.
No,
You don't want to say a little thing.
Hello, everybody. Thank you. As reported, Davis Wright Tremaine.
I've got him.
Really a fantastic opportunity for people to come together, learn, share, network, go home.
Can I thank them first?
And Mark. One of the things we understand about startups is that you have $1 million legal problems and $100 legal budgets. And so we have ways to bridge that gap. So we'd love to chat with you, and thanks for coming.
Thank you. Thank you, Michael. Next, I would like to ask Stanford and Michael to come up from Newmark Knight Frank. Do you guys want that?
Hello, everybody. Whoa. My name is Michael Getz. I work with Newmark Knight Frank, and my partner Stanford and I, we do commercial real estate. And we love being involved with OEN because they are a great resource for many startups and concepts. And we're here for you as well. So if you ever have any questions about office space or need to know anything about a 42-page lease, which is just super enthralling to read through, feel free to reach out to us, and we'll try to answer any of your questions. Also, thanks to Julie for wearing mustard yellow pants. That's literally my favorite color. Not a joke.
Yeah, we had somebody at the last pub talk who was talking about their personal guarantee on their lease. It's the first business they had ever started, and they were sweating bullets because they're so afraid to put all their life on the line. And all we were doing was shaking our heads saying, we would have gotten that off the table for you. But anyway, so we'd be happy to answer any questions you have starting your business and as it pertains to real estate. So,
Thank you.
Thank you, guys. Yes, thank you for our sponsors. We have some amazing events coming up. Hit it, Clara. March 19th, OEN Marketing Workshop, Building a Value Proposition. March 21st, members-only mixer. April 1st, Startup Series. Who's familiar with the Startup Series? Randy. This is a really neat opportunity. We have partnered with Oregon OSU, and it will be, everything's online. Look into it. Office hours, I'm going too fast. I'm going too slow. Office hours in April. What's next? Pub Talk, blockchain. What is it? Who's using it? What else? Startup Resources Trade Show, May 16th. Historically, that's been in December. We're doing it now. And ta-da, the Angel Food Conference, new this year, so really exciting. Hope you can join us. With that, we have we have Randy. I'd like to introduce Randy Herman, who is, I'm going to let him talk about himself, but he is from our startup series, and he has very exciting news to share. And come on up, Randy.
Thank you. So first off, I want to thank Robin and everybody at OEN for putting me up on the stage and for everything that they've done. I was part of the startup series, and it's helped me a ton, which brings me to today. We actually launched our company 2 days ago, and today we are having our launch party. It is Help Me. Help Me is an app that connects DIYers to professionals using video chat. So if you're ever working on a project and you get stuck, you can post your problem to our app, and a professional can view it and teach you through video chat. So they don't have to show up to your house or anything like that. You can still essentially do it yourself. So that's me. It's who I am. If I could, I would love to get all the people who actually have a shirt on to stand up. And Dad, can you come here so I can take a picture? I just want to take a picture of everybody that came to support, and I really appreciate all you guys.
Are you going to tell us how to get the app? Will you tell us how we can get our app?
Oh, yeah, that would probably help, huh? So for anybody, right now it's iOS only. So for anybody who has an Apple device, you can go ahead and go into the App Store, look up Help Me, look for the blue owl. We are like the 6th one down right now, but with all of your help, we can become the first. And that is pretty much it. We will be up on Android within a couple of months, so just stay with me, and I'll be right with you. You get my phone? I want to take a picture of everybody. Mama? Yeah, I just wanted to get a picture. See, anybody can do this. It's always awkward to anyone.
Yeah. Can you do it? Huh? Oh, you're taking a picture. You want a picture of you?
Oh, well, I wanted a picture of the people in the crowd.
You should do a selfie and then all of us
Yeah, turn around.
Oh, hey.
So brilliant. Stephen Caldwell. Are you moderating? Oh, no. Okay. Oh, you're a speaker. Okay. Yeah, we're good. Thank you. Yay! Good job. Thank you, Randy.
Good job, Randy.
Next, I would like to ask Stephen Caldwell to come and give us his 5-minute pitch. Woohoo! Yeah.
With my wife, Lori.
With your wife, Lori. Yay! Do you guys want a mic?
Yes.
He doesn't. No. You want to take it? No. She said you didn't need one.
Do I need one? Yeah. All right. All right. Welcome, everybody. I'm Steve Caldwell. This is my wife, Lori Caldwell, and we are the founders of Rosti. It is a crispy, handheld filled potato snack that we found while in our travels in Brazil about 5 years ago, interestingly enough, in Brazil. And it was a catered dinner, and we had eaten in different parts around the world. We got home, we couldn't find it anywhere, so we created it. And with the help of Sarah Massoni at the Food Innovation Center, she came to us in November of 2017 and said, "What's this handheld snack you got going on with potatoes?" And so Lori and I went down and met with Sarah and the team, and she said, "You're going to Fancy Food 2018. I said, "We're not ready for that. I've jumped way too many times in business," right? So we regrouped in May of last year. She put together a team. Mike Adams, Jason Ball, Sarah Massoni, everybody at the Food Innovation Center were rock stars. We didn't get into ideation until October 16th of 2018, and I said, "We need 5 flavors launched for your winter event. That's really the goal." And we did in 61 days. The next day, we signed Market of Choice, and then we went to the Incubator Village in San Francisco, and since then we have signed 448 stores, and we roll out our first product from our co-packer that we secured in January in May. So I'm going to go right down the list because it's a lot easier to go off of the OEN. So the problem that it solves is there is no filled potato product in the market. In ideation, when we went in there, they spent 2 months regionally and actually nationally trying to find something that was in our space. And so we're actually a category creator. There is no filled potato product. We went from an entree to a handheld because Cam and Jania McMullen from Brazzy Bites, who are on Shark Tank, I spoke with him because I reached out to him, and he says, "Get rid of the entree. Handheld is where it's at." And I said, "Thank you so much." So that's what we've done. The solution is that we are launching our first 5 flavors, our classic raclette, chili cheese, baked potato, fig and goat, and they're all gluten-free, and this is our vegan option, which is a curry lentil, which has got a nice little bite to it. But they're all handheld. Our target market is frozen retail and food service, and we decided to blast out both of them because we've been meeting with Alaska Airlines, Delta Airlines, and American Airlines. They want to put the raclette to start in their food service, in their first-class service. which is pretty exciting. Major chains, club stores, food service, universities, several universities have reached out to us because of the food service. They are all gluten-free, which is nice, and it's a grab and go. Our nutritionals are ridiculous. Each one is about 3 bites, 2 Rosties per serving, and they cap out right around 160 calories. So they're really filling, they're really delicious, and it's truly a culinary experience that's totally approachable because SRP on them is a 4-pack for $5.99. So it's really exciting. You'll see them in May at Whole Foods and Market of Choice locally. Revenue, we're selling through retail and food service. Our marketing strategy is we've done the winter event and we did fancy food. We didn't get into Expo West because it was packed, but we did go down there for several incredible meetings. Our competitive analysis is that there is no one in our space, which is really exciting. And that's our advantage on our end. Any barriers? There isn't any that really exist at this point. Management team is Lori and myself. We have Jamie Tully right here in the audience. She was brought on. She was her last position was with Sweet Earth Natural Foods, and they ended up getting acquired by Nestle. So she's an incredible rock star in our space. I'll take that one. We want to keep it at 5. Okay, second page. So we'll keep answering these questions as I go down. So traction, accomplishments so far. Since the Food Innovation Center, which is I'm so excited about the OEN partnership. It's just, oh my gosh, it's super exciting. And everybody there is rock stars. But HEB, Costco, Whole Foods, Zabar's, QFC, Hagen's, it's going, like I said, 450 in the next week. We'll have, we just signed QFC yesterday, so we'll be in over 600 stores. And this is all pre-rev, pre-product actually. And besides working on in the middle of our second capital raise, we had one raise of 100,000 friends and family in January, and now we're currently we just finished our forecast for our co-packer in Dallas, and between revenue in June through December 31st, we're currently working on a very minimal per week per store at right around 1.4 million, and this all started 5 months ago. So we are so excited to be part of OEN. Everything about this community in Portland has been a huge blessing to us. And if anybody has any questions whatsoever, I mean, our kids love it. You can dress it up, dress it down, and it's really a delicious product. So who's got some questions? Question? There are no allergens. We don't have any. No. Our facility is the first green LEED certified facility. It just opened up a year ago. It's 135,000 square feet. They're currently only at 40%. And what we need specifically is a machine that's a dual encrusting machine that can make these in mass, and we found it. Any other questions? Protein? Proteins right here. We've got, let's see here. We've got dietary fibers anywhere from 4 to 8. Proteins anywhere from 5 to 8. Calories all across the board on a serving size of 2 is anywhere from 130 to 170. So they're just a delicious. Everybody loves potatoes. They come out of the oven, 20 minutes in the oven, and you've got something that you can really add to your meal, whether it's breakfast, lunch, dinner, midnight snack. Thank you. All right. Thank you.
Congratulations. I'll be excited to hear the updates. With that, let's get the show on the road. I would like to introduce again Michael, who is our moderator, coming back up to moderate, to do what he said he was going to do. Let's moderate. Michael. Thank you, Michael.
Hi, everybody. So I'm going to ask the panelists to come on up. And I'm going to let them kind of introduce themselves. Not kind of. I'm going to let them introduce themselves while they're coming up. Want to talk about kind of how we're going to go about this. They're going to say a little bit about themselves. And then since it's Ask the Lawyers, it's not the lawyers tell you, we're going to open it up for questions right away. But I want everybody's attention here. Okay? I got everybody's attention? Unless you signed an engagement letter with one of these 3 people before you got here, these people are not your lawyers. Everybody got that? Good. Now let me give you an example of a question that will not go over big.
Help.
Hi, I'm with ABC. My name is Michael Phillips. I'm a convicted felon, but I'm recovering. Robin and I were co-founders, and she took my IP. Can I sue her? How many people think that's a good question for not your lawyers? Not. Good. That's not a good question. A good question would be, can you talk to me about IP protection? That's going to go over bigger. So everybody, they're not your lawyers, all right? So with that, let's get started. I'm just going to let them walk down the aisle here, introduce themselves,
Hello.
and then I'm going to, I guess I'll throw a question in there to get started, but if people really have a hankering to be first, I'll let you go first in line. All right.
We'll have to. Oh no, they work. They work.
They work? They
No?
work? Yours? Yes? Okay. Julie, why don't you start off?
Hi, I'm Julie Reed, Miller Nash Graham and Dunn. We used to be part of what's called Marjorie Johnson McCullum, which then went wholesale into Miller Nash Graham and Dunn about 7 months ago. I am a patent attorney, so in addition to doing trademarks and copyrights, I'm also a member of what they call the patent bar. I'm an electrical engineer out of Wazoo. Go Cougars. There we go. And went to work at Texas Instruments in Dallas, where I was a digital systems design engineer. They were desperate for patent attorneys with an electrical engineering background, so they sent me to law school. I came back up here. I was in-house patent counsel at Sharp Labs, and then went to Marjorie Johnson about 18 years ago. I do, in addition to electrical engineering kind of stuff, I do all kinds of intellectual property. Lately, I've been doing a lot of chemistry, which I find kind of disturbing because I wasn't a big fan of chemistry, but now I love it. And I've been doing it total for about 28 years.
I'm Mary Hull. I'm a partner at Stoll Reeves. We're a full-service law firm, the largest law firm in Oregon, and I'm a corporate attorney. And so I do a lot of work with startups. Been working with startups for over 20 years. So everything from guy has an idea, he walks in the door, and he's like, what entity do I form? You know, all the way up to financing, angel financing, venture capital financing, and then, you know, eventually, hopefully, an exit, usually a sale of the company. Do a lot of work with tech startups, mostly SaaS, but then a lot of consumer brand companies, too. And as the corporate attorney, you know, my expertise is in executive comp, corporate governance, financing, stuff like that. But the corporate attorney is often seen by the client as kind of the quarterback for the client's legal needs. So, you know, they call me when they have a question. It may be like a labor and employment question or an IP question. I know like a little bit about a lot of things. So I know, you know, some about these guys' areas of expertise, not nearly as deep as them, but enough to like issue spot. So it's kind of a fun role you play for clients.
And I am Blerina Kotori. I do labor and employment law. I work with another large full-service law firm in town called Tonkin Thorpe. Our firm also has a range of clients from very large Fortune 500 public companies to startups, and I work frequently with both. My role is labor and employment. I've been doing this for about 12 years, so I started when I was 13. And usually what I really love about my job is that I get to wear two hats. If things are going swimmingly and my clients are happy and they're just trying to manage their workforce and, you know, avoid lawsuits, they get to call me for advice. I work them through those issues, and we are partners. If for some reason litigation hits, and despite their best efforts, they still get sued, then I'm also there to defend them in court. So I do both litigation and transactional work, and really enjoy it. Not a day goes by where I don't have a good laugh. Yeah.
Excellent, thank you. So, anybody hankering to be first in line up here? There we go. Back there, thanks. Remember, no company names, no individual names.
I don't feel like, oh, there it is. So I'm working in a space where we're sort of deciding between nonprofit and profit, for-profit company. We think we might want to go down both routes eventually. Can you talk to me about like where we should start, what sorts of things we should be thinking about? Just those two topics in general? Is that
Guess that's me.
Come on, Mary. That's a balloon. Just swing. That's an easy one.
trying not to get too specific here.
Yeah, so nonprofits is a really specialized area. Like I represent all for-profits. So yeah, I don't know. I mean, there are two totally different animals. You know, if you wanted to make profit, but you wanted to be like socially responsible, you know, you could consider a benefit company. You know, it's a for-profit company, but you know, you're respecting like the triple bottom line. You know, people, profits, planet. You know, so you're for-profit, but you can be socially responsible and, you know, get at your, you know, motivation to do good that way. But a nonprofit is a totally different animal. You know, there's no shareholders. I don't think that helps you very much. But that's the best I got.
All right, up here in front.
To kind of go off of this nonprofit or not-for-profit thing, I'm working on a project trying to, our client asked to franchise their nonprofit. And I was wondering if you have any advice for that, specifically on how to protect the intellectual property and keep that franchise or that new group from just taking the information and starting their own nonprofit.
Franchise law, like nonprofit law, is a very specialized area of law, but as far as the intellectual property goes, it's all going to be governed by agreement. It's all done, it actually kind of turns more into contract law than it does intellectual property law. It's like contract law with a twist. So you need to make sure that your agreements are very clear about who owns what and how things are transferred, and if, like, you'll need to make provisions. And again, not legal advice. Oh, and I better say this or my marketing director is going to kill me. Miller, Nash, Graham & Dunn is also a very large full-service law firm. Anyway. If you're you need to make sure that your contracts are very clear about who owns what, and if your franchisee make innovations, who owns those? It's all about ownership, it's all about documentation, it's all about making sure that if your people who are doing the franchisee want to hang on to their intellectual property, they need to make sure that their franchisees, the people who are owning the franchises, understand that they own it. So it's all about ownership, documentation.
Thank you.
Yeah.
Yeah, right here.
So technology companies, sort of your bag. Trade secrets versus patenting. At what level do you want to maintain trade secrets with competitive advantage? Keep your secret sauce versus being able to license, but then you are faced not only with patent fees, but registration and maintaining those.
Yeah, trade secrets are a tricky thing because you're supposed to maintain a registry where people that have access to a particular trade secret write down that they have access to it so you can keep track of who has access to it. I worked at a very large semiconductor manufacturing company that a lot of the stuff that they did you would never be able to detect from the final product. So we had a lot of trade secrets. Some of it helped us maintain our competitive edge. So we didn't tell people about it. But the bigger the company there is, the harder it is. You know, I can't remember there's a rule that the likelihood of keeping a secret is the inverse of the number of people that know about it.
What about just as a startup, starting out?
Well, as a startup, the thing that you have to be aware of is public disclosure. If your guys go to a concert, like a road show or a trade show, or they go give a paper or something like that, and they disclose it, there's a clock in the background that starts ticking. So you have to be very careful as a startup as disclosure. If you're working with a bunch of companies, as long as you have non-disclosure agreements, as long as you're keeping everything confidential, my reaction is, and this is not just because I'm a patent attorney, is that once you get to the point where you're getting ready to go to market, get a patent. It's much more defensible than a trade secret, at least in my humble opinion.
Thank you.
Hi, I have a follow-up question about patents. It has to do with provisional patent, the benefits of that, getting that only. And the example would be making a widget, a plastic widget you're going to sell on Amazon, okay? And this came up in the OEN workshop last week. The attorney there said, you know, you can put $20,000 then to follow up with the actual patent, but maybe you're better off spending that money marketing it and flooding the market because China's going to copy it anyway. And if you don't have the money to defend it, and if it's China, I don't know that much about this. I have an idea, like Miracle Mop Lady, but if you could, someone could speak about that, that'd be great.
None of you represent Miracle Mop, right?
No. What's that?
None of you represent Miracle Mom, right?
No.
Okay, good. All right, we can go on then.
I don't know you. Provisional patent applications are like a holding. They're like, exactly, they're a placeholder. They give you a year to file your formal application. A lot of startups, I recommend they start with a provisional. It gives you a year to raise money. It gives you a year to go to the market. It gives you a year in which you can work with other companies. You obviously don't want to disclose everything to them, but it does give you, you know, okay, 6 months from now, you're working with Amazon and Amazon steals your product. You can still point back at your 6 months ago provisional and say, hey, I patented that. You can't do that. No. So I do recommend for startups that they start with a provisional because it does give you time to raise money. It gives you time to get out into the market to see if you have something before you really spend the money on a formal patent application. Going overseas, for most startups, boy, even if you're manufacturing in China or Taiwan or Korea or Japan even, unless you're going to try to enforce your patents there, which means you have to hire a local firm, like you have to hire a Japanese law firm, they have to get somebody to do all the work. Same thing with Europe. I really recommend for startups that they take a really, really hard look at foreign filing. Don't do it unless you absolutely have to. I have some that I recommend to go to Canada. Canada is relatively inexpensive and it's a huge market. Or Mexico, because a lot of people manufacture in Mexico. But all of those deadlines pen from the filing of your provisional application. So in that 1 year where you're looking to raise money to file your formal application, you're also looking to raise money to file in whatever foreign countries you're going to file in. So I do, for smaller companies, recommend provisionals. I think it's a good way to get into the market.
So I guess it seems to me inevitable that someone in, I'd say China, wherever, is going to copy it, and so be it. That's just the reality. Seemingly.
I think yes and no, but if they copy it in China and they try to sell in the U.S., you can stop them.
Huh.
You have, hopefully by then you'll have your formal patent application, you have access to the International Trade Commission, you can stop them from importing if it violates your patent.
So I'm going to grab the mic here just real quickly. I was wondering if each of you could tee up maybe today's issue that the startup missed and is causing major consternation, or we can be more broadly sort of a common, one or two common mistakes that startups make before they come to you, and then sort of how we work around that. What's the solution? What's the consternation? What are the fees?
Sure, I'll start from an employment standpoint. The number one mistake, I guess, or the area that's overlooked for startups is proper classification of their employees. They will often make employees owners and pay them just with equity. When we make money, you make money. Or they will classify them as independent contractors, or they'll classify them as exempt, all of which, if not done according to regulations, can subject employers, even startups, to substantial legal exposure, both wage penalties as well as missed wages. So in, I would say, the majority of cases that we're dealing with startups, they have employees that truly are employees, but the startups view them as consultants or contractors or part owners, etc. The other potential violation that we see quite a bit would be under some of Oregon's more specialized rules of sick leave, providing accommodations, discrimination, harassment, confidentiality issues. For those, you have to be, at least for discrimination protections, you only have to have one employee. For accommodations, it's only 6 in Oregon, and employer startups fall prey to that just because they don't know. They also have a lot of violations with like meal and rest period compliance. Again, very technical rules, posting requirements, very technical. And these are things where defenses, particularly wage and hour, where defenses are fairly limited for employers. It's almost, I mean, there are some defenses, but it's a hard one to undo. So I would say the bulk of the legal expense and exposure goes on those. Yeah.
So an issue I dealt with this week, which is kind of an odd one, but so client is looking to get a raise preferred stock financing round, has a term sheet, and they have like 5 or 6, maybe 7 founders, and one of the guys is kind of troublesome. And so they had, before I represented them, they had entered into a shareholder agreement with all the founders, and they gave each other rights of first refusal if one of them wants to transfer shares and other stuff that's inconsistent with the financing agreements that they're going to need to execute in the preferred stock financing round. And so I was like, well, we got to amend this, maybe amend it out of terminate it, or do something, amend it at least to accommodate the financing round. But in the amendment section, it said they needed every single shareholder that was party to the agreement to agree to the amendment or termination. And so this one guy was really troublesome, and he wouldn't agree to it, and they had to actually pay him money to agree to it, which was ridiculous. I mean, just totally ridiculous. So, I mean, any amendments to your shareholder agreements or whatever, any provisions about amendments, it should be majority rules, so the holders of a majority of the shares of the shareholders party to the agreement can amend it. That's a real technical one. I don't usually see that one. But other ones I see are failure to file 83B elections. So you make, I had this one recently, but it comes up a lot. Founders make their shares subject to vesting, and then they don't file the 83B elections. And so the result of that is if you do file an 83B election, then you take into income when you get the shares, the delta between what you paid for the shares and the fair market value on the date of transfer, which is usually 0, right? If you don't file that 83B election, then on each date when the shares vest, you have to take into income the difference between what you paid for the shares, which is really low, and the fair market value of the shares on that date. So that's just a disaster, because it's phantom income, and you're hoping the value of the shares is going to go up and up and up, but you've got this unknown tax burden coming in the future. And so the solution for that is to just accelerate the vesting of all the shares, which, people don't like, because they put in a vesting schedule for a reason. So that's one. Other ones are, it's hard to raise money, right, when you're a startup. It's hard. Sometimes it's really hard to find investors. Almost always is. And so there's a lot of people out there, and they call themselves finders, and they'll agree to help you raise money, and they'll take a percentage of the money raised. That's generally illegal. So, and putting aside that it's illegal, it's just every finder I've ever seen that does this is just slimy and kind of worthless. Hopefully there's none in the audience, but it's the couple times I've had clients that, despite my saying you can't do that, they've actually done it, and I found out later. They've totally regretted it because the guy was worthless. So putting aside the legal risk, just don't do that. Another problem I see a lot is promising shares to people. So, you'll have a founder who's trying to find a co-founder maybe, and he's like, hey, will you be my co-founder? And, we'll split everything, we'll be 50-50, but without even really thinking about what that means or whether that person's really going to work out. And then it doesn't work out. And so the guy who had the initial idea, the real founder, he kind of moves on. And then, later the would-be co-founder's well, where are my shares? And I contributed to your idea, and I'm not going away. So that's a problem. Lots of problems. I can think of lots, but I'll move on.
Probably the two biggest problems, one is in trademarks and the other is back to provisional patents. With trademarks, I've had this happen twice now to companies, and it just breaks my heart because they started their company, they looked at the Oregon State Business Registry, they looked at the Washington State Business Registry, they didn't see any companies that had their name, and they started their company and they put their website up, and as soon as they put their website up and it went national, a big company that had a trademark that literally had their company name as a trademark, or had their slogan, some company slogan as their trademark, sent them a letter that said, no, you can't do that. One client, well, she was a kind of client, she was a pro bono help kind of business accelerator kind of client. She had to actually change her company name because she couldn't use it, because she was fine when she was just selling in Washington. As soon as she put her website up, they said, no, we have the trademark to that. You can't use it. The other one just had a product line that was exactly the same of a large company's slogan that neither one of us were aware of. I mean, I didn't do any kind of searching, but I'd never heard of it before. But as soon as she put her website up, they were on her, and she had to change the name of her product. So just check beyond just the business registries. There's a free website search tool called TESS. It's the Trademark Electronic Search System, conveniently named. Do a search, make sure that there's nobody out there that has anything that's even close to what you're trying to use before you launch your company, before you invest in your branding, before you put your website up. Make sure you just do a little bit, 5 extra seconds of checking. Make sure you're okay. The other problem that comes with provisional patent applications or with startups in general, startups get really excited. They got products, and man, they're shipping products, they're excited, and they want to get a patent, but they've been shipping their product for 2 years. Well, you can't get a patent if it's been more than a year, so you can't get a patent. And then just one last word with provisionals. A lot of companies write their own provisionals. That's great. The inventors know what they've invented, they know what the market is, they know what they're doing. But have a patent attorney look at it, even if you only have to pay him for an hour of his or her time. Because a year from now, when you go file your formal patent application, anything that you claim has to be in your provisional for you to get that date. Otherwise, the date moves forward, and you've got to go with the date of your filing of your patent application, your formal application. So just spend the money, hire a patent attorney for a couple hours to read your provisional before you file it. Those are probably the 3 biggest things I've seen that startups have done.
Thanks. Right here.
Hi there. I think this is a question for Blarina. As a woman-owned business, woman-focused business, European business, I'm really interested in the welfare of mothers that I employ or potential mothers that I employ. I'd love to know where maternity leave and maternity benefits are going, with sort of trends in employment contracts, please. Thank you.
Sure, of course, thank you. So the main trend that we're seeing now about supporting women in the workplace, and particularly parental leave, is to provide a paid pregnancy leave benefit, because state and federal law, if you are subject to it, only requires that you provide women an unpaid leave benefit for their pregnancy. Depending on how big of an employer you are, even that leave is very limited. So in Oregon specifically, the unpaid pregnancy leave would be, you have to have a minimum of 25 employees. And for federal leave benefits here, you would take 50 employees to attach. There are there is an Oregon sick leave law that will attach with even fewer employees, but unless you're meeting those thresholds, your employees are not entitled to it by law. So enter businesses like yours that are trying to do well by their employees. And what they usually do is 2 types of benefit. One is a paid just allocated amount of time during pregnancy. And then another one is a paid allocated amount of time for parental leave. And now here is where you have to be careful, and where a lot of businesses fall prey, is that they call it maternity leave and they only make it available to women. Whereas in the current workforce, we are seeing more and more men play a bigger role in, parental leave after the baby comes, baby bonding time. So I have seen startups fall prey to that kind of more traditional view, coming out of a good place, but they cause a gender discrepancy when there shouldn't be one. Also, another issue is sometimes it will make a distinction between a woman that had the baby versus an adoption. And legally, on a lot of laws, adopted children and biological children are treated the same. Another big trend right now is this idea of unlimited PTO. And if I can just say a couple things on that and just caution you, a lot of employers use it as a recruiting tool, you know. Oh, sorry, good question. Paid time off, PTO. So a lot of particularly startups will say, come work for us, and as a way of recruiting talent, they will say, we're so great, you get unlimited paid time off if you work with us. If you are one of those businesses that wants to offer unlimited paid time off, just like you heard, maybe spend an hour talking to an employment attorney first, just so that you are aware of some of the potential pitfalls of that program. It's a great program, but what you need to think about is how are you going to enforce it if there is a performance issue? How are you going to make sure that you're not creating unintentional discrimination concern? And then if all of those state and federal laws apply, then how are you going to make sure that you don't run afoul them by creating that unlimited PTO? The other thing that is a trend now is providing some kind of a reimbursement for childcare. A lot of companies, well, I shouldn't say a lot, some companies are considering providing that as a fringe benefit. So instead of providing paid leave, or sometimes in addition to, they'll provide an attached sort of benefit until the child is 18 months or 2 years or whatever. Then the most final trend is kind of the babies at work or infants at work idea. Some companies are thinking about that. Again, if you are one of those companies where you will allow infants to come to work, I think it's worth spending about an hour of your time talking to an employment attorney, because it's probably a really good idea to have a policy. The safety of the infant, you know, who's responsible for that, what happens in the case of an emergency. You know, your business insurance, very often, this is a mistake that people say, is they say, well, I've got insurance. Almost always that insurance does not cover employment liability unless you have purchased it separately. So I would say those are the main trends. Does that answer your question? Okay. The question was whether there is a trend about working from home. There is. I wouldn't call that as a trend. It's more kind of a mainstay now, and it sort of began a few years ago when, you know, with the development of technology, employees could remote in. And that one, actually, in some situations, is more than just a trend. Some employers may have to provide it as a reasonable accommodation if there is a disability. So sometimes an employee that's struggling with a disability, whether it's you know, dealing with chemotherapy, for example, so they have to, they're exhausted, they have to deal with those symptoms, it's easier for them to work from home. In that case, if you were subject to, if you've got more than 6 employees, you would have to provide it, assuming that it doesn't give you an undue burden. So it's more than a trend. Outside of a disability world, if it's just for new moms or new dads, there is definitely an accommodation. The thing you have to be careful about that is that if you do provide it for new parents, you have set a precedent now that your company allows working remotely. And what that means is that it's in your history. So if somebody with a disability comes along later and says, I have developed a mental health disorder of anxiety, going outside, I'm suffering from an acute case of agoraphobia, it's going to be very hard for you then to argue, well, this would be an undue burden if you've already granted it for new parents, right? Because that would be a different distinction. So it's not to say you can't do it. A lot of companies do it. I think it's probably a way to keep employees happy. Happy employees make for happy employers. There's just some issues that I think are worth an hour or two of just talking to an attorney. Does that help? Okay, great.
Hi, thank you very much. Free is great. If an organization is made which is a nonprofit benefit corporation from Oregon, and it accepts money from another state which is not a benefit corporation state, does my organization accept any risk for making an environmental decision?
Can you repeat that? What I got was there's a nonprofit in this state, right, that
Okay.
accepts money from a company in another state?
So I think it's like 35 states around the country have benefit corporations.
Mm-hmm.
Okay. So if I create a benefit corporation in Oregon and I accept money in any form from a manufacturer or individual from another state that is not a benefit corporation state, do I accept risk? Do I have risk in that?
So there's a difference between nonprofits and benefit companies.
Correct.
You're talking about nonprofits?
Both. I'm talking about a nonprofit which is created as a benefit corporation.
Okay. So for a benefit company that's not a nonprofit, that's for-profit, you can accept money from a company in any state. Nonprofits, I have no idea. I'm sorry. I'm not a nonprofit lawyer. I mean, there are really special rules about, preserving your tax-exempt status as a nonprofit, and that's not
One
my
thing to just
area.
keep in mind, too, there's a difference between a nonprofit corp and then a charitable organization. And it gets infinitely more complex and specialized as you go to that charitable designation, the 501c, and pick a number. That just keep that in mind. So a lot of people use nonprofit and that interchangeably, and they are different.
Sorry. Just a follow-up question. So following up on what you were saying for the patent, if a startup was to do what you suggested, right? Is there any other options, or could you think of any other options that they could follow in order to protect their ideas and their products in a way to save money starting out?
Well, if you want to protect products and you're actually selling them, and you want to stop other people from being able to make, use, or sell them, you're going to have to get a patent of some form. Provisionals generally are not that expensive. The filing fee for a small entity, which it's weird, the Patent and Trademark Office provides definitions of everything but small entity. They rely on the Small Business Administration for that. I think the most recent one I saw was that you have to be a company that is not licensing to a larger concern that is between $2 million in profit or under, $7 million in revenue or under, less than 500 employees. The filing fee for a small entity provisional is $140. So if you write it up yourself and have an attorney look at it before you file it, you're probably out $400 or $500, maybe as many as $700, depending on the attorney you pick. But there really is not. Once you go into the market, there's a clock. Like I said, there's a clock that starts ticking. Public disclosure or offer for sale, you have a year before you can't get a patent on that anymore. So it's unfortunate that it does cost some money, but it doesn't have to be brutal. The only other way you can protect your inventions, your ideas, is don't sell them and don't tell anybody about them, which most of your venture capitalists and most of your investors are going to be like, but you got to tell us what you're doing. We're not going to give you money and trust that you're saying. So,
is there a risk that they will divulge the information, the venture capitalist or some type of investor?
Usually, most venture capitalists, and I don't know if there's any VC in the room, no. They usually, first of all, they want you to succeed, so they're going to keep their mouth shut. Secondly, most of venture capitalists, the agreements, and this is probably more her area, there's usually a confidentiality clause.
Yeah, I wouldn't worry about the VCs.
Because you have their money and they want it back, so they want you to be successful.
I think maybe what he was getting at is, and this comes up, is what information do you disclose to a potential VC so that they do end up investing? And I share Mary's, I think even in that instances, if you're dealing with even second or third tier VCs, they're just not going to steal your IP, because if they do it once, it's going to be really hard to continue their practice. So.
I think when you're talking to VCs, like if you want to preserve your ability to file a patent, you can't divulge your secret sauce because they won't sign a confidentiality agreement. So, but you don't need to get into that level of detail with them that you would blow your, yeah.
And a lot of people will file their provisionals before they talk to their VC, before they start marketing. That's one of the reasons that you file the provisional. File the provisional, get your date, then go talk to people and try to raise money.
I work with an accounting firm, and you mentioned something earlier that struck to me. I never planned on standing up and talking, but the non-disclosure agreement. I can't tell you how many times we've been in an entrepreneurial situation and somebody says, well, you will sign a non-disclosure. And we all, of course, say yes. It never comes. So would you describe a little bit about non-disclosure agreements, what they're designed to do, what they do when you sign them, and what they do when you don't sign them? I think people here need to hear this.
Yeah, I can take it and you can kind of supplement. So, sometimes you have like a startup and they want, like, they don't even want to talk to someone at a networking event without having that person sign an NDA, and then they're all concerned about the VCs signing NDAs. And it's kind of like, I don't mean to minimize, the potential risk or whatever, but like, they're not going to steal your idea. Like, it's all in the execution, right? Come on. If you're spending all your time worrying about like NDAs with like someone at a networking event, or like, you just need to focus on your business. So I think you can really get too caught up in that minutia.
Well, and non-disclosure agreements in the IP world serve two functions. One is it basically binds them to keep confidential your stuff. Usually it's typically with the same level of care that they have to keep confidential their stuff. And there are exceptions. If your stuff becomes publicly available, that kind of thing, then they're no longer bound because what you had asked them to keep confidential is now public information. That's part of it, is to just kind of keep your stuff confidential. The other thing is that it works when you're dealing with like beta testers. Software people love to do beta testing, and if they have people sign a non-disclosure agreement, it is basically proof to the Patent and Trademark Office that you didn't publicly disclose it. Nobody can challenge your patent saying they publicly disclosed it because they were working with this developer over here that's not part of their company. Yeah, but the developer signed a non-disclosure agreement. It is basically like, oh, okay, well then it's by definition not public disclosure. So it doesn't affect your patent. But it is amazing the number of people who will want venture capitalists to sign non-disclosure agreements. And non-disclosure agreements don't just cover technical information. They cover financial information, employee rosters, all the kind of stuff that you don't want somebody to come in and steal your employees. And you don't want them to run off with your financial information as much as you don't want them to run off with your technical information either.
Yeah, I think NDAs have a great use, like if you're considering a strategic partnership with some other company, you don't want to really talk to them about what you kind of want to do without, them agreeing to keep it confidential. And it's two ways, right? And you agree to keep their information confidential. So, that's, I think, where a startup is mostly going to use it, when they're kind of talking to potential strategic partners, or maybe they're thinking of a license agreement with another company.
What about they mention it, they want it, and they never give it to you to sign? That's what I'm talking about. There's a lot of exposure.
Yeah, that's interesting, because usually people are either focused on getting it or not, and if they say they want it and they forget, that's kind of odd, I think, but
there is some state law protection that if you tell somebody that something is confidential, even without a signed agreement, that you can enforce them if they run off with your stuff. There is a little bit of, but not much. But yeah, I usually recommend my startups, get an NDA if you're talking to contractors or consultants or people like that. But when you're working with VC, and the big thing is usually when you have a large manufacturer or you're trying to sell your product to a large company like Amazon, who, from what I can tell, Amazon by default does not sign NDAs. Neither does Microsoft. They just don't do it. They're too big. It's too hard for them to keep track of. You either work with them and take your chances. They'll tell you, we'll keep your stuff confidential, but they're not going to get something that they have to police and manage and track. They're too big. They've got too many people. They'd have 4,000 NDAs being signed every day, across the world. So they generally won't sign them, and I get that. I worked at a big company. We were really hesitant to sign them too for that exact reason. But they will generally, they're in business and they do well for a reason. If they were running off with everybody's stuff, they wouldn't be in business for very long.
You make a good point about independent contractors, because I think that's another pitfall for startups is, they're working with an independent contractor, he's developing some IP or whatever, and they don't have a written agreement with him. That happens all the time. And the default is the guy owns what he's created, which is like a disaster potentially, right? Because then you come back later and you're like, hey, can you sign this thing now, this independent contract agreement that assigns to us all the IP you created? And he might be like, no, why would I do that? Like, you should have gotten that up front. That's a big mistake.
Well, and that actually goes not only just to independent contractors, but also to employees.
Yeah, I was just going to
Employment
add,
agreements
if we
usually have
can,
an
By law, the employee, even if you don't get the confidential information invention assignment agreement, if it's really an employee, there is some protection, right?
During employment, there is some protection under the common law duty of loyalty, but after they leave your employment, you know, that's kind of still up for grabs. I would say that non-disclosure agreements are probably just as important if you're bringing kind of the fox in the hen house. And that would be either through employees or independent contractors. With them, you probably do want to have a non-disclosure agreement signed on day one of employment. It's not that you can't do it later. I think state law would probably still support it. It's just that best practice, best corporate hygiene is to have one ready as they walk in the door, and same with independent contractor agreements. I want to echo the point, Julie, you made earlier about what it means to have a non-disclosure agreement and why it's different than just trade secrets, for example, is that you can go broader. You can include in there information that would be business sensitive, you know, client preferences, things like that, that might not qualify as trade secret, but you still derive some kind of value from them. The only thing in the employee world that you need to be careful is that there is an Oregon law and then federal law that says that you cannot say that employees' wages, you cannot require an employee not to disclose their own wages, because it's considered a term and condition of employment, and that would violate Oregon law. So you could, they themselves can disclose. I could go to someone and say, this is what I'm earning. They can't disclose if they're HR, for example. They can't disclose another employee's information, but generally the employer has to be careful about what kind of employee information they include in the non-disclosure.
So this is a question for each of you, or whoever is able to help answer this. A piece of advice I learned early on was to be advised to go into business with a lawyer, like as a co-founder or someone on your board or something like that. And my uncle is actually a lawyer in San Francisco. Whenever I pitch him business ideas, he always tells me why they all won't work, essentially. And so I'm wondering if you have any just kind of general advice that how can you get more lawyers on your side as you're starting businesses and starting startups, essentially.
Yeah, so I don't think you need to make your lawyer like a co-founder or put him on the board, him or her on the board of directors. Like, if some lawyer is asking you to do that, I think that's really weird, and I would totally resist that and not do that.
Probably unethical, too,
I mean,
right?
it would be
You
like
can't-
so
yeah.
strange. So, but yeah, I mean, especially like in this town and in Portland, I mean, there are like so many lawyers, and like they're all like pretty generous, you know, with their time, and they offer like very favorable fee arrangements to startups. And so I think there's no shortage of legal help here that you can get in an economical way. And now if you have like a uncle and this happens a lot, that if you have some uncle who's like, you know, a corporate lawyer or whatever, then that's awesome. Then he's gonna like really just help you for free, and, you know, that could be a good business advisor, and that's great. But you don't have to, you know, give him like 10% of the company or something. He's lawyer, he's been practicing a long time, he's got enough money, right? I mean, so yeah, it shouldn't, don't need to do that, so.
And I also would probably add to that is, you know, we're lawyers, we're not business people. If you have an idea and you have something that you really like, and a lawyer's like, oh, I don't know if that's gonna work out, don't listen to him. We are supposed to provide you legal advice and help you figure out a way on how to make this succeed, not to hold you back and tell you whether a specific business idea that you have is terrible. If a client, and I've had clients that have asked me before, Blarina, do you think this is going to make money? And I'm going to be honest with them. I'm going to say, I have no idea, because I really don't. But I can tell you what can help you get there and what can help you not incur any liability. But in the list of things for you to worry about, what your lawyer thinks about your business idea probably shouldn't be high up there.
Totally.
Well, and that's a good point, because I have clients who come up on decision points of, do I need to file here? Do I need to file there? Whatever. I can advise them, and I'm happy to advise them as to what the risks and rewards of the various points are. And I had one client got really mad at me one time. He's like, just tell me what to do. And I said, as your lawyer, it's not my job, it's not my role. I'm your advisor, you're the decision maker. And my last law firm, I was the president of the last law firm I was in twice, and it's a completely different gig, right? You're a decision maker. we're not decision makers. We advise you on the various effects of stuff of your decisions, but we're advisors. We're not the ones who make the decisions.
Yeah, thanks. I have two questions. One on the NDA topic. I am a consultant in food, and I sign a ton of NDAs, some of which have timeframes of defining how long they will be in effect, many of which don't, and sort of the clause that says, remains in effect until terminated. And so I'm wondering if I'm just leaving these out, like maybe I have a client that I've worked with a couple years ago, and I never terminated that NDA. What's the exposure for me in relation to that content that we have discussed? And do I go back to them and clearly terminate that NDA? What's my role in that?
So I can get this started from a consultant, and then we can all pitch in. So when you say as a consultant, I assume that you've kind of been their independent contractor and you've advised them, and during the course of that project, you collect the information, right? So generally speaking, NDAs do not have, the majority of the ones I see do not have a time limit. And so what that means is that that's depending on how the contract was written, and if it was written well, there is a chance that that non-disclosure is good forever. And so the risk to you would be if 2 years have passed and year 3 you decide, that was something that I learned, and you disclose it, goes around, if it harms them, et cetera, they could have a claim for breach of contract against you. Now, realistically speaking, you have tools to try and prevent that from happening. For example, there's nothing that stops you from reaching out to this specific company you worked with to say, hey, remember me? We worked together a couple years ago. I have this opportunity. You don't have to discuss it with them because you don't want them to scoop it up if there is a question of competition. But just say, can we terminate this officially now? Some of them will say, yeah, sure, no problem. And you gauge there how much they care. Some of them might tell you absolutely not, and you will know through that answer who might be likely to really get upset about it. You could also agree to amend it. But again, if somebody wants to say no to that, they probably might say no to the amendment. But again, you would have to breach that contract somehow, meaning that you'd have to use whatever they defined as confidential information and belonged to them in business for the benefit of some other reason, or disclose it for some other person or some other reason. And that wouldn't be good for your business in any event. So I don't know if that would be the specific scenario, but there's nothing that stops you from at least trying to end it.
Right. Well, in terms of the food world, at least, you develop specialties and expertises in certain product types. Sure. And so I might make a veggie burger with product or company A, and then 5 years later, I might want to make a veggie burger with company B. And so how do I defend myself from, just breaching a contract with company A from 5 years ago?
Right, and again, on the non-disclosure side, and maybe you guys can talk about whether that's intellectual property that belongs to them in terms of the recipe, but from the non-disclosure standpoint, from the non-disclosure standpoint, you're bound by the contract that you sign, right? And if it has no end in sight, you can't unilaterally inject one. The best kind of approach in that situation for you as a consultant would be to negotiate with them an end. Or going forward, when you sign one on the front end, when you have a little bit more of that leverage, say, can I put this date in there?
Also, as a consultant, I guess, if I were you, I wouldn't work with like 2 veggie burger companies, right? Because, you might be, if you're working with 2 customers that are so close and they're competitors, you might be at risk maybe even inadvertently using confidential information of one and disclosing it to the other. So that's one thought. And then the second thought is, I think also like the longer you go out, if you signed an NDA with a customer like 5 years ago, the longer you go out, companies move so fast and they change all the time and stuff gets obsolete really quick. So the longer you go out, the less likely I think there's going to be a problem. But
for intellectual property non-disclosure agreements, there generally is a time. There's usually 2 times. There's a time that you sign that says it's effective as of this date for X amount of time or up to this event. And then usually the duty of care to keep their stuff confidential usually goes for it's anywhere from 3 to 5 years after the termination of the relationship. So if you're an independent contractor and you're going to work with somebody for 6 months, they'll say this agreement is effective for 6 months, and then for 3 or 5 or however many years after that, you're responsible for keeping their stuff confidential. But like Mary was saying, things move so fast, and one of the exceptions that makes things no longer required to be kept with the duty of care is that it becomes public information. And if things are moving fast and they're putting products out there and that stuff becomes public information, then the duty goes away. It's an exception to the non-disclosure. So,
and the exception to exception is unless it becomes public through your action.
yeah, not
and
you.
then, so don't do that.
Somebody else told them, not you, right?
Right.
Hi. So let's say I'm starting a new business. I have absolutely no idea what I'm doing. Do you have a suggestion as to like practices, mindsets that you've seen help companies protect themselves legally as they get started and as they grow?
You find an organization like OEN, and they will. I mean, they have. There's a lot of groups around that have kind of fundamentals of starting a business courses and stuff that you can take. That, like OEN, there's a couple incubators around. You talk to them, and they can kind of help you figure out. And most of them have been through this more than once. So you talk to them, and they tell you, like, what kind of not just legal issues, but business issues and that kind of stuff you're going to run into, and they can help you find the people that can help you.
Thank you. I just have a quick question. There's probably a lot of people in the audience who are employees, but also that's their day job, and their nights and weekends they do their side business. What if their contract with their employer says that their employer has rights to everything that they could possibly conceive during the time of their employment? How does that change if they're an independent contractor, and how does the state of Oregon enforce that law? And does trying to renegotiate your contract constitute admission of something that you may have already contemplated?
And we'll continue with this seminar in an 8 session on that question. No, I'm kidding. Go on.
Okay. Well, so there were 3 questions there that I think I heard. So let me try to do kind of an overview of them quickly, and then obviously with other situations. A lot, and you're not going to like this because it's a lawyer answer, but a lot of it depends on what the contract says, right? A lot of employment agreements will say that everything that you invent on our own time, using our resources, etc., belongs to us. And a lot of contracts will have a caveat that actually carves out and says your personal time, as long as you're not using company resources, company confidential information, etc., it's yours. If the contract doesn't have that caveat, sometimes what it has is when you come in, list all of your inventions in Exhibit A. And that's a really tough scenario for employees because it's kind of a decision point, right? Do I want to take the risk and disclose these things to the employer? Or do I take the risk that I might not have this job, right? Because an employer can insist that you sign this contract and can fire you if you refuse to. That would be a legitimate business reason. As a general rule, employers are kind of like VCs. They really don't care about stealing your kind of idea on the side that you're working on or something that might be very important to you, but it's not really in the business of the employer. Where I have seen this in a few cases become an issue is where the business of the employee that they were trying to create was very close in nature to the business of the employer, and it was very difficult to parse what was the idea, the personal idea, versus what the employee was getting paid to do. And in those scenarios, if you wanted to diminish legal risk, I think it would benefit the employee to engage in an open negotiation with the employer to say, here's everything that I have. Let's do a mutual confidentiality. I don't use yours, you don't use mine. I don't tell anybody about your stuff, you don't tell anybody about mine. But it gets a lot more malleable. So that's the part where I think it can get sketchy. With independent contractors, I think the same sort of idea would apply, except that independent contractors are not like employees. With employees, there is common law where something that you invent on the employer's dime is the employer's, even if you don't have an employment agreement. With the contractors, not so much. You have more of an arm's length bargaining situation, so you have some more leverage there. The third question was something about what? Remind me again. What was your third question? How does what? Okay, so I think I just answered that in terms of what, common law for employees and then sheer contract law. So basically, that would be enforced through litigation.
We're out of time.
Oh, can I just chip in one
Of course.
last thing? For the employment agreements, a lot of times the employers will give you a letter that says that they have no interest in your invention as long as you grant them a royalty-free perpetual license to the invention. I've done a lot of those because I was in a legal department of a huge corporation. We actually had one guy who invented an automated bird feeder, and my company, the company I worked for was a huge digital signal processing, semiconductor processing company, and they said, you know what, we don't even need a license back on that because we don't have anything to do with birdhouses. But an engineer's an engineer's an engineer. We tinker, trust me, I am one. We know how it works. And so they will usually, and it's usually a good idea for the employee, especially if it's not really close, to disclose that, hey, I'm working on this thing, and get a letter from their employer that says, we have no interest in that. But even though we have no interest in that, we want a royalty-free, perpetual paid-up license to your IP. And that's only really for them to cover their risks. They're not going to go off and start making automated birdhouses.
All right. Thanks very much. It was great. A little round of applause for our panelists. My friend Julie says, fill out the surveys. So please fill out the surveys. And I'll do something that all moderators do to panelists. I'll volunteer for them to stay after and answer your questions. So thank you very much. And I'm leaving.